Hey, Tony DeWitt here, Missouri Appellate Attorney. I'm retired, and this is not legal advice. Everything I say is simply commenting on the law. And this will be what we're commenting on today. So, today we're back in the Timothy Harrington trial in Mississippi, and we're going to look at some video of the cross examination of one of the police witnesses in that case. Now, for those of you who may not have been following this, Timothy Harrington is accused of murdering Jimmy J. Lee. There's never been a body found, and the police really don't have any forensic evidence that ties Harrington directly to anything that happened to Jimmy J. Lee because obviously they can't find Jimmy J. Lee. The state has a very circumstantial case built here, and I think it's actually a quite good circumstantial case when you put it all together. But as you know, the defense's goal in one of these cases is to take one brick at a time out of that wall of evidence that the state is putting up. So, in this first exchange here, let's listen to some questions about lab and fingerprints.
Thank you, Your Honor. Director, I want to clear something up a little bit. Y'all received your final report on the DNA September the 5th, 2024, correct? That's my understanding.
I don't know when the final report was received. You referenced that?
My understanding is that things were submitted to the lab immediately after, once retrieved, and lab reports came in periodically as to when things were coming back to y'all.
Yes, sir.
Okay.
The final lab report, I don't know the exact date. You referenced that, but
Basically, that's just a couple of months ago, but y'all had reports throughout. The final report that got y'all combining everything was sent September 5th, 2024. I don't want to confuse the jury, correct?
Okay.
Also, I want to ask you, as far as I asked you about going back to Molly Bar. Y'all also took the fingerprints out of Mr. Harrington's apartment, right? Y'all do print analysis there?
I don't know.
Baker would be better to tell him to say it, right?
I don't think Ryan was there either. I think, or Detective Baker. I think Detective Rachel Carver was the one doing that with the other individuals there. Myself and Detective Baker took Tim Harrington back to CID to interview him.
But your understanding is that y'all did print analysis, trace evidence, I should say print analysis. Y'all lifted prints, it's in the reports at Harrington's apartment, right? And the trace evidence that we talked about as far as collecting items for the purpose of trace analysis, right?
Yes, sir.
And you also found in the apartment when you searched Mr. Harrington's phone and his computer, right? We talked about that earlier.
Yes.
So those were done forensic analysis for those two machines, right?
Yes, sir.
And trace analysis for the physical items out of the apartment, right?
Yeah, they would have gathered, collected items.
Right, okay.
Now, hopefully you noticed something there. We're not going to talk about that, but at least not now. But before we go too much further, I want to talk a little bit about how I was taught to cross-examine. And the reason I'm doing that is because you're hearing a lot of ahs and uhs and that sort of thing from the lawyer. I don't mean any criticism of him. He's got a difficult job and he's working on the fly here. And so, again, no criticism, but this is what we are taught, at least in my firm, how we're taught to handle a cross-examination. It's all about leading questions. That's because an adverse witness, and of course the police agent in a situation like this is an adverse witness, they can be examined by leading questions. And leading questions, of course, are questions that essentially suggest the answer. When did you stop beating your wife? That sort of thing. So the general principles of cross-examination are: first, help your case. Get facts in there that the witness may not want to give you, but which he has to give you. Get those. Hurt the witness before the jury. Expose his or her bias, their lack of preparation. or sometimes sloppy work. It's often said that without cross-examination, the right to counsel is meaningless. Cases are won on direct, and they can be lost on cross-examination. Let me give you an example from my own personal history. Now, I lived in Jefferson City, Missouri for quite a while, and there, like a lot of places, there are people who are cut from a little bit rougher piece of cloth than the rest of us. And I was called to testify in a domestic relations matter to the fact that children in my neighborhood were out playing in their front yard, which doesn't sound like much until you realize that it was 20 degrees outside and they didn't have on any coats. One of them didn't even have on long sleeves. So the petitioner's attorney, who was working for the wife, took me through the direct examination. Why was I there? Well, I lived there. What did I see? Well, I saw those kids walking around in the area with no coats on, and it bothered me, and I told my wife about it. Now, she never asked me what my opinion was, so I'm not an expert, right? And that was it. That was the end of, I established that they were out there without coats on. The defendant in that case was being defended by himself. He was pro se. So he strode confidently up to the lectern and said, "You're not a doctor, are you?" And I said, "Yeah, I am. I'm a Juris Doctor." His face turned beet red. He was so mad. "Well, you're not a medical doctor, are you?" The judge rolled his eyes. Couldn't believe this guy was going there. I said, "No. In fact, you don't even have any medical training, do you?" I said, "Well, that's incorrect. I was a combat medic in the Army, and I spent 13 years in healthcare as a respiratory therapist." So, wow, 2 strikes. But he had to go for the third strike by swinging for the fences. "Well, that doesn't qualify you to give an opinion on whether it's safe to let kids play outside without a coat, does it?" I said, "Well, I don't know. We'd have to ask the judge." But I wasn't giving an opinion because it's within the province of the average juror, or in this case, the judge, to know and understand that good parents don't let their kids play outside in 20-degree weather without coats. By now, the judge was covering his face and laughing to himself. Of course, the guy couldn't see it because his back was turned to the judge. And he asked a few more meaningless questions, and every time he asked a question, I used it to buttress the petitioner's case. And then he sat down. What that shows is really that preparation is kind of the key to being good at cross-examination. You have to know the facts, you have to know how to do everything that goes into setting this up so that you don't get up there and set your entire case on fire with a witness. If he had asked me if I was so worried, why didn't I call the cops, he might have scored a few points with the question. As it was, the judge severely restricted his visitation. Now, a few years later, this poor guy was running from the police on a motorcycle, and he ran straight into the back of a semi-trailer, and as you might guess, he thereafter assumed road temperature. The moral of the story, though, is when you're cross-examining, don't do yourself any harm. Don't give the witness an opportunity to repeat testimony he's already given. So there are 3 rules in cross-examination: leading questions only, 1 new fact per question, and you question in a progression leading to a specific goal. The lawyer is the one testifying in cross-examination, and the goal is to build facts that persuade and convince. That's different from speechifying. You don't want to get up there like an orator. What's important is to build up a series of facts that cause the fact finder, usually the jury, to say, "Okay, I'm convinced of this central issue." Because it's all about perception. Everything lawyers do is about perception. We have to create the perception so the fact finder understands where the facts fit in the case. Because you can't outvote a person's feelings. And what the fact finder believes is the truth. That's where they're going with it. Lawyers are taught to use leading questions because the lawyer is really the one testifying. If the lawyer gives this up, the witness begins to testify, and heavens, you don't want that. You want to tell the witness the facts and make them say yes. And if they don't say yes, there are special tactics that we use to convince them to say yes, because we can usually make that a very painful experience and we'll do it repeatedly until they start playing the game the right way. So to do all of this, you narrow the field of evasion. You give them nowhere to run. You take the verbs out of cross-examination. You never use who, what, when, where, how, why, or explain this. The lawyer is the voice of certainty, and he comes across as very certain while he's doing this cross-examination. Not so much this lawyer in this case, but that's the whole goal. And you do it in terms of chapters and goals. So a chapter is one group of leading questions that go to one factual goal. In this case, that they didn't find any fingerprints of Jimmy J. Lee in Harrington's apartment. A good direct exam or cross-examination of an expert is a series of chapters, and a chapter is a goal-oriented exercise. The goal is to get every concession from the opponent's witness on cross-examination that the lawyer can use to advance his case. You have the witness admit things that are favorable to your case and things that are unfavorable to the adversary's case. If the admission exam is successful, a lot of times people will just quit while they're ahead so that they don't stumble later on and wind up undoing all the good that they've done. And then the next thing that happens is you attack the witness's beliefs. Now, you don't attack their credibility at this point, you attack their beliefs because you're criticizing their testimony, not them personally. That's a really important part of cross-examination, and that's the basics. Now let's get back to the cross-examination of this officer.
And I want to just kind of, so after y'all covered those things, it's a fair statement that didn't make any effort to go back to Molly Bar at any point in time to do any similar type searches of any apartments or anything over there at Molly Bar at any point in time.
I don't recall, I do not believe either that we searched any apartments over there.
Well, in one of the reports, there was a report in OPD, and I don't know if you're familiar with, I hope you are familiar with the fact that during the course of this investigation, I went to an apartment that was unlocked. The officers went in shortly after this incident and did a safety search in there because it was open and unlocked. Went in, looked around a little bit in Molly Bar Trails Apartments, right?
Okay.
Close proximity. That's not a very big complex, is it?
It's not just one way in, one way out.
Right. But shortly after, and I think it was somewhere around July the 10th or 11th, officers with OPD and UPD, while they were searching out in an area, one of the apartments was open. No one in it, but it was open, and they walked around, looked around, right?
Okay. Yes, sir.
And
Now the objection here is to the form of the question, because it sounds like the defense attorney is trying to get the officer to testify to things he did not personally do. That's not what the lawyer is doing. He's asking for his understanding. The discussion from the bench is not loud, and it's not loud enough really to make out the arguments well, but the questioning continued in much the same vein, with again the lawyer saying, well, I'm asking about your understanding of what was done, not what you did. So let's watch that.
Is the appropriate, rephrase the question to, does he know if the course of investigation was this or was it?
I will, Your Honor. I guess I'll find it in here, the two officers that went in there. I'll take you a few minutes. But your understanding is, based on the reports in the file, that during the search of the area, after y'all had found the car, looking around in the area, like you testified about on direct and cross at Molly Bar, that some of the officers, during the course of that search, went into an apartment that was open, basically did their own. They went in primarily because you didn't know if they were going to find any evidence in there, but characterized in the report as a safety search, right? Is that right?
I was not there. If you're saying they did that,
If there's a report to reflect that,
then it must have happened.
So all the state did by objecting here was to convey to the jury that they were worried about this particular issue. Now notice what the lawyer has done here. He's shown that the state did not collect evidence from an open, unlocked door in the complex that Lee was taken out of, or supposedly taken out of. It's sloppy work. In order to get them to open that door at the end and convict, they have to close all the other doors in that corridor, and this one is standing wide open. Now, they could have gotten a warrant and executed a full search because it was an open door. There was this incident that happened, but they didn't do that. They did a safety search. Now, a safety search is an exigent circumstances search where you don't need a warrant if lives are in danger. Yet at this point, there was really no evidence put forth about whether or not there was even an exigent circumstance. Even if they had obtained evidence out of that search, it probably would have been excluded because they did not have a warrant and there were no exigent circumstances at the time. But did you notice something about the officer here? Let's take a look again. I'm going to put up a couple of circles here and you'll see what I mean. Do you see that on all these questions that go sort of more or less to the issue of competence, they seem to draw a nervous tick from the officer? I wonder if we'll see anything about that on closing. To be fair, he had this tick when he testified on direct. I apologize for the quality of the video here, but you can clearly see him do this. It could be that he's just nervous, or perhaps he has some kind of neurological condition, but it tends to make him look dishonest. So hopefully, if the state wanted to be successful here, the prosecutor had him explain why he does that on direct exam. I didn't find his direct exam because it doesn't appear to be on YouTube, at least that portion of it that discusses anything that he might have done in terms of his nervous tick. But I thought it was very important, at least in this instance, to point out that that's something that a lot of lawyers, at the end of the testimony, at the end of the cross-examination, they'd ask him a tough question, one that they'd saved back, maybe one that they set up with other questions. And when he did that, when he was answering the questions, they would have said, you know, I noticed every time I asked you a hard question, you had this tick. What is that? Because it calls the attention of the jury to that tick, and it puts some doubt in their minds about whether this guy is telling the truth. I may have told this story on the channel before of a witness that I was cross-examining in a deposition, and every time I asked her a tough question, her neck turned beet red. And eventually it would go down, but every time you ask her a question, and she lied, because she always lied, her neck just turned beet red. It was a huge, display of what I would call guilty knowledge. And we pointed that out in the deposition. Hey, why is your neck turning so beet red? Now, this was a video deposition, so the cameraman got the beet red color change. It was pretty impressive, actually. So again, hopefully the prosecutor, if he wants to win this case, explained that on direct. So that's what I have for you today. Thank you so much for being here. If you have the opportunity today in this Christmas season, go out of your way, do something nice for someone. And then when you've done that, drop some comments down below, give me some questions, whatever you'd like. You can email me at the address above. And as always, like I said, thanks for being here. Come back tomorrow. Join me down here at the beach. We'll talk about something else. I shouldn't have to say this, but you don't seek legal advice from a guy down at the beach. You seek it from a lawyer in a lawyer's office, where there are people running around in suits and secretaries and all kinds of other people. I'm just a YouTuber. I'm a retired attorney at this point, and although I retain my license to practice in the state of Missouri, I am not here dispensing legal advice. I'm just offering general content on the law. And here are some videos that YouTube thinks you may enjoy.